what if they pay for part of the damage, but then say this isn't storm damage when you think it is? So it's, you're getting some money, but then they deny other portions of the claim.
Yeah, and I was going to address this later, but I guess I'll go ahead and do this now. And there is a pitfall in this TWIA policy that people need to be aware of. And at the end of this presentation, I'll show you what this document looks like. How about that? Because I'd like to hear Lance talk about the types of policies that TWIA covers. But if they accept part of it and deny part of it, that's pretty common. If they deny the parts that they denied, they will write out, you have 2 years to challenge that. So don't forget these deadlines. You have 1 year to make your claim. So don't be confused there. But if they deny your claim or any part of it, the parts that were denied, you have 2 years to challenge that denial. The part that they accepted, and I'm going to say it here, and then we're going to come back to this in a minute, 'cause it's so important. The part that they accepted, let's say they accepted your roof, but they didn't pay you enough for your roof. You only have 60 days to contest the amount that they paid you on the part they accepted. And that's the part I want everyone to know about. And there's certain things you have to do to protect yourself. But before that, what if they just say no? What if they just say, we're not paying you? I want to show you what that looks like. And we've already given you this. But this is a typical no. So it would be, here's your cover sheet, and it says, see your attached letter, and there's the letter, and then there's the decision right there. So you'll see, hey, we're denying your claim. And then they say, we deny your claim in full. Now, if this is the situation, this is pretty easy. You have 2 years to challenge this. So my advice to you is, if you disagree with this, you should talk to a lawyer. Like, you should go and consult with a lawyer to find out what about this denial that you feel like is something that bothers you and you don't agree with. I generally have found in my career that my clients tend to guide me to the reasonable things. And if I just listen, they'll get me to the point that's probably unreasonable. And the general rule of this is really important. When do insurance companies have to pay you for your claim? It's when liability for that claim is reasonably clear. It doesn't have to be crystal clear. Tie goes to you. If you like baseball, it's tie goes to the runner. You're the runner. So if it's a close call, they should find a way to cover your loss. But if you get that full denial, you have 2 years. Now, what Christina asked, and I'm going to show you, and I've got now, is here's what we see a lot. And can you see that okay, everyone?
Yeah.
Okay. So what you see is part of your claims accepted and part of it's denied. Now, they'll come through here and they'll say, here's the part of your claim that we accepted. Like right here, they accepted the rear elevation. And then that's the part that they issued a payment. But in this case, they said that amount of damage wasn't as high as your deductible. So they didn't get a payment here. But they did accept part of the claim. Now, what do you do about that? If they accept your claim, but don't pay you enough money for the part that they accepted, and there is treacherous ground that you're on right here. And this is something that I want everybody to know. Lance wants everybody to know. We care a lot about the people there. And you're not going to see it. It's that deadline's not going to jump out. If you notice at the end of this page, they'll tell you there are deadlines that apply to disputing the amount that they accepted. That's what that says. Now, they don't tell you what that deadline is. In fact, you have to scroll down. This is the part they denied. You know, you have 2 years on all this. You got to scroll down again and scroll down again into the letter. You still don't have it. You don't know what your deadline is. You've got to go to the FAQs they give you. And then right here in this section, I lost count, maybe page 6.
6 or 7 at least.
6 or 7. And it's on page 2 of it. It's right here. You have 60 days. I highlighted it. 60 days to challenge the part that they accepted. And the only way you can challenge that is through appraisal. So the first thing I want everyone to know is if they got part of their claim accepted, or maybe all of their claim accepted, maybe they didn't deny any part of your claim. You have, but you think they didn't pay me enough money. I can't fix it. I can't put my home back or my business back the way it was prior to the storm with the amount of money they paid me. You have 60 days from the date that letter, it says right here, after you receive this letter. So 60 days from the letter to challenge it. And the only way you can challenge it then is by going to appraisal. So this is important. That's another real technical thing. My advice to you, to everyone, now this is for informational purposes. We don't represent anybody watching this video. We're happy to talk to you. But my advice to you, if you were my mom, I would say, if you get a letter like this and you don't think it's the right amount of money, I would advise you to consult with a lawyer and say, hey, what should I do next? How do I do this appraisal? Because appraisal is a whole nother thing that's going to cost money. You got to select someone to go and write an estimate for all your damages. And usually contractors only are going to write the part that they want to work on. So you need kind of someone that's going to write an estimate like the insurance company did. And you need to get that done. You need to notify TWIA first within the 60 days that you don't agree with what they paid you and that you would like to go to appraisal. My recommendation is to get someone experienced with this process, a lawyer, someone that has that kind of expertise and has people that they can hire to do this appraisal for you. We pay our appraisers by the hour, so they don't have any incentive. They have no bias. They don't have an interest in your claim to give us the kind of line by line adjustment, just like TWIA got for you, so we can figure out what that amount of loss is. So you might ask, well, how much does appraisal cost? I would say on average, anywhere between $1,000 to $5,000 is what I've seen over 20 years of doing this, depending on who you hire. And it's a process. But I just want to circle back and say one more time, if they accepted your claim or even a part of your claim, the only remedy, the only way you have to challenge how much they paid you for the part they accepted is the appraisal. And you've got to tell TWIA within 60 days of your letter that, hey, I'm not happy with the amount you paid me. I think it's wrong. And I want to take the next step to challenge that, which would be appraisal.
Clint, I think that's a great explanation. Most people, when they hear the term appraisal, they don't think of anything like you just described. Appraisal is someone going out and just telling you what your property's worth, and that whole process is even foreign to a lot of lawyers. A lot of lawyers are not familiar with the process at all. So, in addition to the short time frame of 60 days, then they throw in this foreign procedure that most people don't understand or appreciate. So that's all a great explanation for that.
Well, and
yeah, it's not a real estate appraisal. Yeah,
that's right. And that's what everybody thinks of when they hear the word.
Yeah. And yeah, go ahead, Christina.
Well, I was going to say, like, they have to pay for that. Like, I would have to pay for that, not my insurance company.
That's right. You would pay for your appraiser. So if you hire a lawyer, someone like me or Lance or someone else that does this, that has experience, make sure your lawyer knows what they're doing. Make sure they understand that, not only do they know insurance policies and experience there, but they also know the TWIA policies, because it's different. Appraisal works differently inside of the TWIA policy than it does a normal homeowner's policy. But yeah, we would hire someone. And by the way, just to give you an idea, Lance and I would hire someone with experience in TWIA policies and in the TWIA process, because the TWIA, the way it is you pick an appraiser, they pick an appraiser, and then the two of them pick an umpire. And so you need, and then they give you a list. TWIA does. You don't get to just pick any old umpire. It's got to be in their little universe. So Lance or I would say you make sure whoever you're hiring is familiar with TWIA, with the rules, with the policy, and all that. And that's important. And again, 60 days from the letter, you've got to start you don't have to finish the appraisal within 60 days. You just have to tell them within 60 days, I don't agree and I want to participate in appraisal. And here's the name of my appraiser. And so we pay for that. So we front that expense for our clients and we carry that cost the whole time. And for people like Lance and I, we don't charge by the hour. So you might ask Christine, I don't know if it was on how can people afford to hire a lawyer? Did I steal one of your questions?
That was my next question. You mentioned kind of a couple of consults. You should consult an attorney. Like, how much is that going to cost everyone, right?
Well, Lance, you want to take this?
Yeah, so you don't pay us anything unless or until we get you a recovery. It's a contingent fee contract, which means a percentage of the recovery is what is paid to us for our time, in addition to the out-of-pocket expenses that we may pay to work on your case, like the appraiser that Clint just mentioned. So there's a stair-step percentage depending on what stage of the claim we're able to get it resolved. If we get it resolved at an early stage, then the percentage is lower. If we end up having to go through appraisal and potentially file a lawsuit, then the percentage goes up, obviously, because of the time commitment and level of work that's going to be required at that stage.
Now, hold on, Lance. What if someone came to us and said, I'm not happy with what I got paid, but I've already been paid $20,000. Are you going to take a percentage of that?
Absolutely not. Whatever you have coming in the door is yours to keep. You're never going to go backwards by hiring us. And so if you have an amount that you've already received prior to hiring us or any other attorney, that should be your money without any percentage coming out of it. So our fee would only be based on, I guess, what I would call new money that we may get because of the work we do for you.
Did you have a question, Christina? I'm sorry.
Well, I was just going to say, so like in a situation where I've gotten a denial and I think that my roof damage is valid, I never had any roof issues before, and I reach out, I schedule a consult, that's free. If I hire you and then you send someone else to my property or you invoke appraisal and you don't get anything, I don't owe you anything, is what you're telling me?
That's exactly right. If we don't get you a recovery, then you don't owe us a dime, and whatever we spend on your behalf is just it's part of doing business on our side that we absorb.